Hello and welcome to ET Now. I'm Ashwin Mohan and you're watching Amicus Curiae, where we get you news and views that you can use from the world of corporate law, tax and regulatory affairs. And this week, it's a no-brainer. We are going to look at the ripple effects of the revised Indo-Cyprus tax treaty. And to throw more light on that front, we're joined by two voices from the world of tax, Tushar Sachade from PwC and Anil Talreja from Deloitte. Gentlemen, thank you so much for taking our time and joining me on the show this week. Let's start off with you. This was clearly a move on the cards for a long time, especially after the government went ahead and revised its long-pending treaty with Mauritius. What do you make of the timing?
I think this has been kind of envisaged from 2013, right? So from the time the Cyprus was named as a non-cooperative jurisdiction, the Cyprus government has been pushing for removal of that tag, and the Indian government has been pushing for kind of renegotiation of the treaty. Now, given in international politics, Cyprus did not want to give up their capital gain exemption under the treaty, but now that the Mauritius treaty has been renegotiated and the capital gain exemption has been taken away from the Mauritius treaty, it's absolutely right time for India to push its way through in terms of renegotiating the Cyprus treaty and kind of, in exchange, give the assignment of the notification which termed Cyprus as a non-cooperative jurisdiction.
And obviously Cyprus did not have too much of a choice because that entire tag of being a non-cooperative jurisdiction was hurting its investment image. So it had to in fact take the plunge sooner or later. And Cyprus over the years has been very popular with a certain segment of investors, especially those in the real estate space. If you look at the flows that have come in, we're talking about around 42,000 crore rupees from 2000 to 2016. So it's not a space or a jurisdiction that you can really ignore when it comes to the fund flows. What do you make of this back-to-back revision of treaties? One, Mauritius, and now Singapore. The government seems to be on a roll.
No, absolutely right, Ashwin. If you look at it in retrospect, prior to 2013, so prior to November 2013, Cyprus was one of the most attractive, so to say, jurisdictions to invest into India. There were various reasons. You mentioned real estate. There are lots of funds which wanted to go into Cyprus, and there was a lot of play around debt. And that's mainly account of the fact that interest withholding tax rates between the India-Cyprus treaty were pretty much at the all-time low. But having said that, as we rightly discussed, there was a conversation between the two countries right from the time that Cyprus was blacklisted. Their popularity dropped. And thereafter, there was no conclusion between the two countries. But I think the way the Indian government has played this is commendable, because first what they did was they gradually reduced the capital gains tax rate under the domestic India tax treaty from 20, for example, to 10. That's the first move they did. And obviously the other important move which happened was change of minds, because we had the earlier government and the new government. And that again played a big role, because then a lot of messaging has been sent to foreign investors that India is still one of the best places for you to make investments, and given the market size. But you're right, the timing is quite good, because the way it's worked is that the Mauritius amendment has pretty much pulled the trigger for other countries to now be serious and trying to come to a conclusion. And perhaps this is one of the outcomes that we are witnessing at this point in time.
Tushar, if you look at the amended treaty, this particular treaty is something that, as both of you are pointing out, was in the works for a long time. But if you look at the treaty per se, it follows the same script as Mauritius, because there's a grandfathering element that has been introduced. And based on the grandfathering element, it's only the investments post April 1st, 2017. It's only after that trigger that the capital gains right is given to India. What do you make of it? There seems to be a fair level of consistency in the manner in which the Indian government is approaching these revised treaties.
Yeah, so just to kind of caveat it, that we haven't seen the text of the protocol as yet in case of Cyprus, but if we kind of
if you go by the statement at least that has come in from the Cyprus government.
Yeah, if you go by that, you're right in terms of there's a consistency in terms of approach. What Indian government does not want is that they do not want to give any tax arbitrage to any country. The intent of the Indian government is that to renegotiate treaty to give Indian government right to tax capital gain, and that's the theme which is across being followed. The other important aspect which is very good, and I think we should commend the Indian government for that, is that they do not want to do anything retrospective. The intent of the grandfathering is that going forward, these rules will be applied. In terms of past, we are protecting your investments which are made. Of course, there are certain uncertainties and in terms of the way the grandfathering will be read. So, for example, the words used in Mauritius Treaty is the shares acquired prior to 1st April 17, and probably the similar language would be used in Cyprus Treaty. The question is, what do you mean by shares acquired? Versus, if you look at in terms of GAR grandfathering, which just got announced about a week back, the wording used in that case is investment made before 1st April 17. So there is a kind of subtle change in difference in language between the two.
In the drafting.
That's correct. And the question comes up at that there are several issues related to that in terms of, say, convertible instruments, where you invested, say, prior to 1st April 17, and the conversion of the shares, which are, say, preference shares, happens after 1st April 17. What happens in those situations? Because the wording uses shares acquired.
All right.
Similarly, in a debenture, you'll have a similar issue. Similarly, what happens to the bonus shares, which are just an accretion to the original investments, right?
Absolutely.
So these are the issues which are going to come up, which will need to be addressed. And I think government has been proactive. And good part is that there's already a working group which has been formed by the government in respect of the Mauritius Treaty, where hopefully these issues will get addressed. And if that happens, probably that would also apply in case of a Cyprus Treaty. So I would say, yeah, there is a consistent kind of approach that the government is following. I think one issue that we should debate here is that the right approach by the government? So should government use tax treaties as a positive arbitrage? The view of the government is no today. The way the things are going, based on if you see what is happening, that they're taking away capital exemption. So should government kind of use taxes as an arbitrage to kind of attract foreign investment?
Anil, do you concur over here, his line of thinking?
No, I would agree.
Okay.
But just to add, maybe once he's finished, just to add, I think an important aspect here is whilst the government perhaps is on the right path in terms of the approach that they are sort of following, although it's not really getting shown in that sense. But I have a very important aspect here, just to add on to what Tushar
Sure,
says,
go ahead.
is that if you look at the way the government has reacted to some of these announcements, so the April 1, 2017 is a very critical date. The government is actually giving a message that, look, forget prospective as of from today. We're giving you another few months.
So get your act right
to try
before
and
April
get your
1st,
act together.
2017. That's sufficient time for investors to reject their entire structures, right? Tushar?
Yeah, in a sense, that way from April 17 is not far. But if you look at from where they started, it's a sufficient time, right? Because we are talking about GAR implementation for last 3 years. So long as there's enough time which is given, and so long as there's a grandfathering which is given, there's a sufficient time for people to restructure their businesses.
How significant is Cyprus' route currently as we speak? I know we referred to some of the real estate investors using it in the past, but how active is that route as of now?
As of now, so there are the fund houses and investors who have significant substance in Cyprus. So, and secondly, if you look at Cyprus happens to be part of the European Union, right? So, as a EU nations, there are regime, for example, AIFMD, right, which is the fund alternative investment fund regime, where you can register and then market your fund in the European Union. So it's not that Cyprus only is used for the purpose of tax benefit or kind of a low withholding tax on interest. It's been used also with the intent to raise funds, create substance, and kind of market in the European Union. So there are fund houses which are genuinely based out of Cyprus, and in case of fund houses, there is always a need to pool capital, right? So it's, if I want to market my fund to a multiple investors and want to pool, I need to find a place where I can pool, right? And Cyprus happens to be that one such place where you can pool capital and market into EU. So there are commercial rationales and reasons for the people to kind of invest out of Cyprus. And I'm aware of the fact that people who have substance are still using Cyprus in some cases. It's not kind of used very extensively because of the fact that it has been like a kind of has been treated like a non-cooperating jurisdiction. But there has been fund houses who are using Cyprus today. And you said the numbers, right? The 3,000 crore of FDI which came in the last year from Cyprus. So it's not that it's been only not been used at all.
So it still continues
correct.
to be pretty significant. Anil, you want to add something?
The way I would look at it is perhaps slightly differently. You mentioned in your question, how is it looked at it now? I mean, now if you ask me from a perception, from conversing with a lot of investors and clients, I think Cyprus is really not talked about. Again, we see the numbers, there is FDI flows in, and my personal view is that the reason why the FDI is flown is because those structures have already been put into place. And then perhaps there is no option but to live with those structures. But if you ask me how much of new structures have been given birth at the Cyprus-India level, I think it's pretty much nil, because the negative sort of perception that was created after India sort of blacklisted Cyprus caused enough damage for investors to look at Cyprus as a fresh jurisdiction to invest into India. So the existing funds did continue, and I'm aware of that. But fresh investments are pretty much out of the block.
So it'll be an uphill task to get back to the glory days.
Yes, and you will have competition from Mauritius and other countries as well. So that's another.
So I principally agree with this statement. But the point is, there are existing funds with significant substance. So I agree that in terms of new fund setups, investors have started looking elsewhere because of the unfortunately notification that Cyprus had in terms of non-cooperative jurisdiction. But going forward, of course, it again will open up discussion between once this treaty is renegotiated and the notification is resigned, it will open up discussion in terms of even for debt. Now that the Mauritius will have 7.5% withholding tax rate versus Cyprus, if the rate is not changed, will have a 10% withholding tax rate, which is the jurisdiction you'll use. And there will be there will be fund houses still will choose Cyprus over Mauritius. Say, for example, if they're based in EU and they're looking at investments from the EU investors, then they will have no choice but to be in a European Union and register themselves.
So clearly, you're pretty bullish on Cyprus.
I'm not saying pretty bullish, but I said what I'm saying is that it is not that Cyprus will not be used at all going forward.
I get your point.
Right now, I agree with Anil that there is an issue because of the cooperation tag that Cyprus has.
I get your point. In fact, you spoke about substance, and that's where I want to bring in the LOB element. Now, we unfortunately don't have the entire detailed draft of the amended treaty, but we do understand from a few senior government officials that there is no LOB element as far as the revised treaty is concerned. Anil, how do you approach this particular aspect?
See, essentially, if you see even the changes that were made to the Mauritius treaty, technically there is no LOB element. The LOB element kicks in only in the transitional period, just going very technical by the law. It's a different thing that today we advise clients to have substance, and it's actually it's in the interest of everyone to have substance. But technically it's the transitional period, which is April 1, 2017 to 31st March 2019. That's where the LOB is kicking in, even in the amended Mauritius treaty.
That's when it really matters.
So I'm not very surprised to hear that there is not going to be any LOB in the Cyprus treaty. Again, not having an LOB doesn't mean you should not have substance, because that's the criticality of using a tax treaty.
But LOB just pushes you to do
just
that.
Fortifies that,
What do you have to say on this?
Yeah, I think two aspects. One is LOB, as Anil rightly pointed out, it's basically in respect of investments which are made post April 17 and exited before March 19. So it has a very limited play. And in terms of private equity investments or a foreign direct investment, generally you do not expect people to exit within 2 years. So as such, it has very limited.
4 to 5 year horizon.
That's correct. So that way, on a private equity or a FDI investment, it has a very limited application. The only application, main application that the LOB has is in the context of the foreign portfolio investment, where people are doing short-term trades, which is where you will have a 50% tax rate applicable if you are trade in that period. Now, I'm not sure how much was the FPI investments coming from Cyprus. So, given that, I don't see that to be a kind of negative impact. What is also important, of course, that we need to see how does the LOB or even the grandfathering plays with the new GAR rules which come in effect from 1st April 17.
That interplay will be interesting.
That interplay would be interesting, and even while there is a LOB, whether LOB will override GAR or GAR will override LOB is a debate. Now, even in jurisprudence, you don't have a clear answer to that questions, and probably government should come out with a clear view so that people are, and the theme of the government is to give more clarity and transparency in terms of interpretation.
And they've created a facilitator atmosphere.
That's correct.
And they've always sought feedback from all the relevant stakeholders before unleashing any new tax policy.
Correct.
On that note, gentlemen, we'll have to slip into a short break. Stay tuned to ET Now and keep watching Amicus Curiae. Welcome back to Amicus Curiae, where we are discussing the implications of the revised Indo-Cyprus tax treaty. Now let's speak about the entire aspect of exchange of information. And that's clearly something which the government is betting big on, because one of the main reasons why they had notified Cyprus as a jurisdiction which does not cooperate was because they were not giving the information which the Indian government wanted relating to certain account holders. If you look at the trend that the government has set, clearly we are looking at an atmosphere where there is going to be more transparency and there's going to be more exchange of information. And that will definitely help the government get the right kind of information, which so far has been deprived of, right?
Yeah, so I think if you start, say, in November 2013, when Cyprus was notified as a non-cooperative jurisdiction, and the main reason for the Indian government to do that and take a unilateral step of notifying Cyprus as the only country under that section was that government was uncomfortable in terms of the exchange of information that Cyprus was doing. And therefore, I would not be very surprised, and I would rather bet on it that when the new treaty comes, there would definitely be kind of the negotiation which have happened in terms of the exchange of information, which will come up. I think the other aspect is if you look at the whole world, right? Look at the OECD, the discussion which is going in OECD. The whole world is moving toward the common reporting standards. At some point in time, India would also kind of adopt the common reporting standards when it comes to exchange of information. And that is the important aspect, because without the exchange of information, Indian government is kind of uncomfortable in terms of the data it gets, in terms of black money, in terms of corruption money, and they want people to kind of, the countries to kind of agree to a common reporting in respect of the reporting of the information. So maybe Anil can...
in fact, I wanted to take off from this. Don't you think this is a very stern and strong message sent out by India to other jurisdictions as well? Because clearly there were negotiations going on for 2 years between India and Cyprus. And as we were mentioning earlier, Cyprus had no choice because it had to get that tag removed. So don't you think this is a clear message sent out by the Modi government to other jurisdictions as well, that if you do not cooperate when we expect you to cooperate, then you'll have to pay the price?
No, it's certainly a very firm message that has been passed on by the government. And I think it's in the interest of the country and the economy as well. I mean, we talked about OECD. Now, we all know about the fact that OECD has launched so many initiatives. For example, BEPS. It's now being digested by various countries as part of their law. So that is actually an international law whereby you have international sort of GAR, so to say, you know. And with that in mind, and if you want to have BEPS implemented in India, and by Indian corporates or by companies which are investing into India, you have to have these sort of agreements. Otherwise, you can't implement something that has been planned. So I believe it's a good message that is going up to various countries. And more importantly, if you look at the developed countries, you know, if you look at the tax treaties that they have signed up, you know, these sort of exemptions don't really exist. They seldom exist. So ultimately, India has to reach that level where you are then proved to be a developed country, and you don't have sort of the best way to invest into India and things on those lines.
What kind of an impact do you think this will have on some of the other treaties?
I think before we go there, I think one point I wanted to make on the earlier point is that the country-by-country reporting, which brought in the last budget, is effectively in line with the whole, you know, kind of exchange of information. Once there's a country-by-country reporting happens, then India will have information in terms of the global, you know, multinationals as to where are the profits being set and whether there's a erosion of tax which is happening.
There will be a global database.
That's correct. Now coming to the next questions.
What's the impact on other treaties? Because there are several other treaties which could be potentially renegotiated.
I think Singapore has to be the next one, logically, because the fact that Singapore Treaty, when the SICA was signed, was kind of linked to the Mauritius Treaty renegotiation, and effectively, because of the Mauritius Treaty renegotiation, Singapore Treaty is, in essence, has got renegotiation from 1st April 17. Now, unfortunately, there is not going to be grandfathering in Singapore automatically, right? So there has to be a negotiation between two countries, which has to take place to ensure that Singapore gets the grandfathering provisions and also whether the transitionary provisions do get introduced or not. Singapore interest withholding rate is set 15%. So whether does it bring in line with Cyprus at 10%, or does it, or 7.5%, which is under the Mauritius treaty that they're given. So that's, or is Singapore, given the trade relationship with the country and the whole the economic cooperation agreement that India has signed, does India give up something more to Singapore compared to Cyprus and Mauritius? It would be an interesting kind of negotiation.
Singapore is definitely next in line. Anil, you look at M&A tax. Put yourself in the shoes of an investor. What would a foreign investor be keen on looking or spotting when it comes to a tweaked Indo-Singapore tax treaty?
Well, the way I would look at it, and putting myself in the shoes of an investor or a person who wants to do an acquisition into India, I would typically look at Singapore as a company to invest into India if I have a plan to expand in the Asia-Pacific region. See, if you look at the way Singapore's position geographically, look at the time zone where it is actually a very good sort of location for an Asia-Pacific hub. So if I were to sort of expand into the Asia-Pacific region, I would certainly look at Singapore to make investments.
And what changes would you look at in the tax treaty?
In terms of changes, I think the expectation that I would see is that it will be exactly identical to what has happened in Mauritius. I would actually be very keen to see what is going to be the change, if at all any, in the interest withholding rates. Because still, the way India has now negotiated with Mauritius, it's half of what today the withholding tax rate is with regard to Singapore. So I would look at that as one of the critical elements. Again, I would look at it only when I'm looking at debt. Otherwise, it doesn't make sense for me to look at that. But overall, if you ask me, I would also try and see somewhere down the line, if you look at the future, if you do a crystal ball raising and look at the future, look at 2019-20, these treaty benefits are not going to be available. So there is definitely going to be a tax element in India. And that is where, I would try and see if I can model out the capital gains tax as part of my investment philosophy. I think that is something that's I would look at, unless I'm looking at exiting using other modes, for example, listing into India, in which case I don't have to really go to the treaty.
Absolutely. Tushar, what about the Netherlands treaty? That's another aspect.
Yeah, so what we heard is that Netherlands also might get renegotiated. The Netherlands treaty as such has a limited capital gain exemption. So it has a capital gain exemption where there is a sale from one non-resident to another non-resident. So long, I think that I think Singapore will be first, and probably Netherlands thereafter will get renegotiated at some point in time because of the capital gain exemption, limited capital gain exemption, which is available under the Netherlands treaty.
Closing words from you on the Netherlands aspect?
Well, certainly it's on the cards. I think the government has also initiated a conversation, is what I understand. And I expect that, as Tushar says, Singapore, Netherlands is what you would perhaps see in the near future. And the message that India is again trying to give is that we're still a better place to invest. It's only that we need to get more clarity into what the future is, rather than litigating as to what is substance and whether the treaty benefit is available or not. I think the message is to try and get more clarity and certainty into our tax laws, which I think is what is being top of mind and top of agenda for the government.
Absolutely. On that note, gentlemen, we've run out of time on the show, and I must thank you both for taking out time, dropping by and helping us understand the implications of the revised Indo-Cyprus tax treaty, and not only the Cyprus treaty, but also what could be in line as far as some of the other pending treaty negotiations are concerned. Thank you so much.
Thank you. Thanks.
With that, it's a wrap on this edition of Amicus Curiae. This is Ashwin Mohan signing off. See you next week.